who should discover any new refinement in luxury. Jewish law includes several considerations whose effects are similar to those of modern intellectual creation as property does not seem to exist. Notably, the principle of hazard J.U. Vale was used to justify limited term publishers copyright in 16th century. Then origin and development of intellectual property right at international level. For the protection of industrial property, the origin and development of intellectual property rights under international law date back to 1883 with the adoption of Paris Convention. In the territory of member state, Convention protected mainly three classes of property, namely patents, trademark, industrial design, that is only industrial property. With the member state, the convention entered into force in 1884. It was revised several times, the latest being in 1967 at Stockholm. The first international convention on the law of copyright was Berne Convention for the protection of literary artistic work in 1886. Its aim to protect to literary, artistic, creative works. At Paris, the convention met with several revisions, and the latest being 1971. For the protection of intellectual property, these two conventions have established an international regime. There are also a number of other conventions and treaties dealing with specific category of intellectual property. Under the patent regime, Patent Cooperation Treaty, Washington, 1970, Traceability Agreement concerning the International Patent Classification, 1971, Budapest Treaty of International Recognition of the Deposit of Microorganisms for the purpose of patent procedure, 1980, are important treaties. A number of international conventions were adopted on copyright law in the late of 19th century. The important convention in the field is Universal Copyright Convention, 1952. In the member state of the Berne Convention, a Berne Union, Berne Convention for the Protection of Literary and Artistic Work, 1886, protect in an effective and uniform manner the right of authors in their literary and artistic work. The Berne Union required the members' country to grant moral as well as economic rights to author, such as the right to object any destruction, mutilation, or other modification of or other derogatory action in relation to his work which would be prejudicial to an author's honor or reputation. The Berne Convention also provides for national treatment according to which work originating in one of the member states are to be given the same protection in each of the member states as the latter grant to work of their own national. Since 1974, the World Intellectual Property Organization, which is a specialized agency of the United Nations, was established by a convention on 14 July 1967, which came into force in 1970. In the era of intellectual property, it administered a number of international unions and treaties, such as Paris and Berne Convention. Initially, in 1974, the Paris and Berne Convention that were administered by separate offices and then together in Berne. The object of World Intellectual Property Organization is the promotion and protection of intellectual property throughout the world among its 197 member states and to ensure administrative cooperation among the union established to afford protection in the field of intellectual property. World Intellectual Property Organization carries out many tasks related to protection of intellectual property, such as administering international treaty, assisting government organization and private sector, monitoring development in the field, and harmonizing and simplifying rules and protection. At present, the TRIPS cover 9 categories of intellectual property. The TRIPS agreement consists of 7 parts with 3 articles. It has enormous impact and drastic effect on our social, economic, legal, and cultural life. Many important sectors of our socio-economic activities like trade, technology, agriculture, health, education, and welfare have been affected by becoming a member of the WTO and TRIPS and influencing inclusion of more new items in TRIPS make it more complex. The whole idea of intellectual property rights so far incorporated in the TRIPS agreement has been comprehended in four multilateral conventions, that is Rome Convention 1961, Paris Convention 1962, the Berne Convention 1971, and the Treaty of Intellectual Property in respect of integrated circuits 1989. Then what are the origin and development of intellectual property rights at national level? At national level, the origin of intellectual property can be traced back to the ancient days when monopolies existed in the Byzantine Empire. In the 17th century, ancient Greece granted monopoly to cook for 1 year to exploit new recipe. But a few centuries later, Emperor Zeno in Rome rejected the concept of monopoly. The development of Indian intellectual property law has been influenced by Western development of intellectual property law. The English people had brought the law in India. Hence, the Indian history of protection of intellectual property rights through legislative enactment and judiciary has contributed a lot on its part in extending protection to the owner or licensee of trademarks who used to seek remedy under the provision like the Indian Penal Code and the Pacific Relief Act for the protection of their rights. Section 490, 479 to 489 of the Indian Penal Code provides for penal provision for the protection of trademark. The aforesaid provision were not adequate for the protection of intellectual property. There was need for special statute at national level. The copyright law was made its way into the Indian subcontinent when the English East India Company extended the English Copyright Act of 1842 into India. The act has been modified in 1911 and later in 1940, a new Copyright Act was enacted. With a view to consolidating and amending the old law, the Copyright Act was re-enacted in 1957. The Copyright Amendment Act 1994 has also enlarged the scope of protection of computer program. The Amendment Act 1994 conferred the copyright holder with the additional exclusive right to sell given on hire in copy of the computer program, regardless of whether such copy has been sold or given or hired on earlier occasion. In 1856, the first Indian Patent Act has been enacted to grant exclusive privileges to inventor. The aim of the act was to enable English patent holder to acquire control over the Indian market. The Patent and Design Act 1882 was enacted, which was followed by Invention and Design Act 1888 subsequently. The purpose of the act was to protect the interest of the industrialist, manufacturer, and importer. In 1911, the Patent and Design Act was passed again, which was the first comprehensive law on the subject. It remained in force until the passing of Patent Act 1970. The Patent Act 1970 has been amended in 1999. In India, the design law was codified with the Patent and Design Act 1872. The provision concerning the patent were separate from 1911 Act, and the design provision of the Act remained in force till the passing of the Design Act 2000. In compliance with GATT and TRIPS, the Trademark Act 1999 identified the
Sir, sorry for the interruption. Sir,
yes, ma'am.
Can you please conclude with a couple of minutes?
Okay, madam. The Trademark Act 1940 was brought on the statute book, laying down the specific law on the subject, which was repealed by the Trade and Merchandise Act 1953. For the registration of the trademark service, the Act 1958 did not contain any provision and the definition of the term registration. Subsequently, the Trade and Merchandise Act 1958 has been repealed. The Trademark Act 1999 has been enacted by the Indian Parliament. The purpose of the Act is to amend and consolidate the law relating to the Trademark Act for goods and services and prevention of the use of the duplicate mark. The new Act has been made the new clear The law clear certain the unambiguous effect of acquiescence. According to the provision of Trademark Act 1999, the central government made the trademark rules 2002 and enacted the Trademark Act 2010. Then what are the future prospects of intellectual property rights? As technology advances, the use of intellectual property rights will become more complex. With new form of technology, it will become easier to copy and dispute context without permission. This should lead to more piracy and infringement of intellectual property. Regarding intellectual property rights, more countries develop their own law and regulation. Stronger intellectual property protection will help to develop the global economy and increase international cooperation among nations. Owner of the intellectual property right will have to plan for global protection. The future of intellectual property rights in India will depend on three things: awareness about IPR, benefit, stronger enforcement, and convincing Indians that the national interest will not be compromised. To promote innovation, creativity, and intellectual property rights protection, the future perspective intellectual property in India looks promising, with several initiatives being taken by the government. For intellectual property, the Indian government had introduced several reforms to strengthen the legal framework. The aim of intellectual property right policy are to create a comprehensive intellectual property right ecosystem in India. Then conclusion, the intellectual property regime has been subject to criticism throughout its history. As innovative industry continue to play a more significant role in the national economy, awareness of intellectual property has grown along with diversity of perspective traveled by the intellectual property law implication. The concept of property in information is little more than bad metaphor. In recent years, for example, the term copyright protection has significantly increased. The scope of patent protection has expanded to include business method, and trademark law has embraced the expensive dilution doctrine. As technology advance and the digital world continue to grow, so too will technology property right. We can hope that the future of intellectual property is one in which creators have a better chance to protect their creation from misuse or exploitation. Thank you for giving me proper time.
Thank you, sir. Ma'am, can we proceed with further participant?
Yes, we can proceed for the next participant.
Yes, ma'am. Thank you, ma'am.
Next presenter.
The next paper code is A13, Jagadish A.T., co-authored with Dr. Priya A. Jagadish, Assistant Professor, Law College, JSS Law College, Mysuru. Sir and Madam is going to present on the paper Protection of Intellectual Property Rights in Cyberspace. Over to you, sir and madam.
Thank you, madam. Respected, am I audible?
Yes, sir, you are.
Yes, you are audible.
Yes. Respected chairperson and co-chairperson and my dear fellow participants, the title of the paper is Protection of Intellectual Property Rights in the Cyberspace. With the given 10 minutes of time, I would be very brief in my presentation to start with a brief introduction for the need to protect the intellectual property rights in cyberspace. Mainly, I have dealt with two important forms of intellectual property, that is the need for protection of copyrights in the cyberspace and the trademark in the cyberspace, followed by I have a new introduction called as NFT, non-fungible tokens, which are of late in news, and yet to decide on what form of intellectual property that non-fungible tokens are to be protected, which are considered to be one of the important digital assets in the days to come. And in my paper, I have also focused on the challenges faced in protecting IPR in cyber law and the various theories that would focus on the protection of IPR. The jurisdiction of intellectual property issues in cyberspace, followed by conclusion. So this is with regard to the brief synopsis of my presentation. To begin with the introduction, as I said, with the proliferation of e-commerce on the internet and related aspects such as electronic payments and taxation have taken place, thereby which has led to the increase in infringement of intellectual property rights in cyberspace. In cyberspace, as we know, one person makes a profit by using another person's creation without the owner's consent, which has become rampant nowadays with the skyrocketing in the use of internet. This is a violation of privacy and it has to be protected by intellectual property rights. I agree that we have certain laws to avoid the violation of intellectual property rights in physical world as well as in cyberspace, but effectively it has not been dealt with. Some of the examples of violation of intellectual property rights in the cyberspace includes copyright infringement, software piracy, cyber squatting, etc. in the intellectual property age. And the protection of intellectual property rights requires even greater attention and a dedicated strategy for its protection. There are various theories which discusses the need for protection of intellectual property rights, and also we have India's new intellectual property rights policy, which also focuses on the protection of intellectual property rights. This paper focuses an attention on the challenges in protecting the intellectual property rights in cyberspace. As we have already aware with regard to the what constitute intellectual property rights, as said by the WIPO, it includes 7 main forms of intellectual property rights, and Article 2 of the World Intellectual Property Organization, which says that an intellectual property shall include rights relating to literary, artistic, scientific works, inventions in all fields of human endeavor, scientific discoveries, industrial designs, trademarks, service marks, and commercial names and designations, protection against unfair competition, and all other rights resulting from the intellectual activity in the industrial, scientific, literary, or scientific fields. So this is an attempt to tell you what is intellectual property rights as per Article 2 of the WIPO. Coming to the challenges faced in protection of intellectual property rights in cyberspace, there are new varieties of hybrid IP infringements. To start with, the infringement of intellectual property would include, under copyright law, framing, deep linking, inlining, sale of pirated products poses a high challenge to the law enforcement authorities. Many websites today offer freeware installations, sell pirated software copies, and engage in other criminal activities. So despite the technological measures and legal framework, combating copyright infringements continues to be a major challenge in cyberspace. So this is one of the important challenge. And moving on with the next challenge is trademark infringement, which is in the name of what is called as domain name disputes or cyber squatting. This cyber squatting refers to a phenomenon where it has gained enormous significance. So to expand on the copyright infringement, we have this what is called as linking, which refers to directing a user of a website to another web page by action of clicking on the text or image without leaving the current page. It poses a threat to rights and interests of the owner of the website, and the owner can lose the income as it related to the number of users visiting the website. Similarly, we have deep linking, which is challenging to manage as there are no clear-cut laws at both national and international level, and this framing, which is another challenge, issue, and database and a debate subject over the interpretation of derivation and adaptation under Section 14 of the Copyrights Act 1957. Section 14 of the Copyrights Act 1957 deals with works in which copyright subsists. And coming to the software piracy, which refers to making unauthorized copies of computer software which are protected under the Copyrights Act 1957. This piracy may be of following types: soft lifting, software counterfeiting, renting. These are some of the software piracy. Moving on with the next form of intellectual property, which has been rampantly violated, is trademark. And trademark under the concept of domain names, what we call it as cyber squatting. As I already explained to you, this cyber squatting is a cyber crime which involves imitation of a domain name in such a manner that the resultant domain name can dupe the users of the famous one with an intention to make profit out of that. Very recently, there has been an attempt to register the name of the daughter of Zuckerberg, the founder of the Facebook, where Facebook founder Mark Zuckerberg had to pay a huge amount of money to purchase the domain name from one of the engineering students from Karnataka. So these are some of the examples. And there is another thing called as meta tagging. It's a technique to increase the number of users accessing a site by including a word in the keyword section, so that such search engine picks up the word and directs the users to site despite the site having nothing to do with that word. So these are some of the intellectual property rights infringement which we are able to see on the cyberspace. Moving on, the theories to need to protect intellectual property rights on the cyberspace would include the natural theory, utilitarian theory, Champatrian theory, deterrence theory, personhood theory, the ethnic and reward theory. And there are various justifications for the protection of intellectual property, such as labor justification, economic justification, personality justification, Marx theory on property. Right. And moving on with the international law governing the protection of intellectual property in cyberspace, would start with the Berne Convention of 1886, Madrid Agreement concerning international registration of trademarks 1891, Hague Agreement concerning the registration of international designs 1925, Rome Convention on the protection of performers, producers and phonograms and broadcasting organization 1961, Patent Cooperation Treaty 1970, Agreement on trade-related aspects of intellectual property rights 1994, which is popularly called as TRIPS, World Intellectual Property Organization Copyright Treaty 1996, World Intellectual Property Rights Organization Performance and Phonograms Treaty 1996. And in spite of which, we also have what is called as UDRP, Uniform Domain Name Dispute Resolution Policy. So these are some of the legal framework at the international level which provides for the protection of intellectual property rights in the digital world, as well as that is the cyberspace, as well as in this physical world. Coming to the jurisdiction of intellectual property issues in cyberspace, which requires to be addressed very urgently. As we all know, that cross-border disputes against private parties and hybrid infringements are an emerging concern as the globe shrinks into cyberspace with no boundaries. Courts face a constant dilemma of which cases come under the purview of their jurisdiction for prescription, adjudication, and enforcement. The objective aspects of territorial jurisdiction is crucial to this. A sovereign has a power to adopt criminal law that may be applicable to offenses that effectuate within the boundaries, even though the offensive act was committed outside its boundaries. Of course, in the so-called developed countries like US, there are certain theories which are developed, such as the most noteworthy of which are minimum contacts test, the effects test, and the sliding scale test or Zippo test. So these are some of the theories which have been focused worldwide to effectively address the infringement of intellectual property rights on the cyberspace.
Sir, sorry for the interruption. You're just left out with a couple of minutes, sir.
Yes, madam. I'll conclude it. So coming to Section 75 of the Information Technology Act, which deals with regard to the offences committed outside India, as well as Section 1 Clause 4 of the IT Act deals with this. So this is regard to the jurisdiction. I would like to focus upon a few issues such as. Hello, madam, can you mute yourself? Right. So coming to the conclusion, there are few important points to be focused upon. The first is to focus upon the effective implementation of National Intellectual Property Policy 2016, and there should be awareness created of intellectual property rights, not only in the physical world, but also in the cyberspace. Effective enforcement of the existing laws to protect intellectual property rights, the both national laws and the international laws, periodical amendment to existing laws in contemplation with the developing artificial intelligence and other technological development, harmonization of this intellectual property rights in accordance with international standards. So these are some of the important points that I want to focus to effectively protect intellectual property rights in the physical world as well as in the cyberspace. Thank you. Hello.
Yeah, okay, thank you, Jagdish.
Yes,
So, next presenter, coordinator. Yeah, Kalpa, next paper presenter.
So next it is A15.
Thank you, Jagdish.
So,
thank you, sir.
so next is A15. Rutu Shivani R, co-authored with Kirtana Purnesh, School of Law, Christ University. A paper, protection trademark on cyber. Am I
audible? This is Rutu here.
Yes, you are audible.
I'll be presenting my screen right now. In 1 second. Good afternoon to everyone present here today. My name is Rutu and my co-author's name is Kirtana Purnesh, and we are from School of Law, Christ deemed to be University. Today, we are presenting a paper on brand battles in cyberspace, unraveling the trademark challenges in the digital era. So just to give an overview about our paper has been divided into the following subsections. One, we are talking about the background as to how did the evolution of cyberspace begin and what exactly is the concept of internet and the emergence of domain names, and a concept of cyber squatting along with certain examples and cases, deep linking, inline linking, meta tagging, product disparagement, and social media challenges. Further, we move on to unraveling the trademark challenges in the social media landscape. So here in this paper, we attempt to cover two broad spheres, one being on internet and another being on social media platforms. And we also go on to explain whether hashtags can be trademarked and what is the legal stance of trademarking a hashtag in India. And we also cover the intermediary liability of social media influencers when it comes to trademark violations and infringements. Further, we conclude the paper by providing suggestions and what can be the way forward of the paper, and my co-authoring will be presenting the last half of the paper. Unlike the conventional world, territorial borders do not exist in the virtual world. On the internet, there are neither political barriers nor are there any territorial demarcations. So the cyberspace is one single space devoid of any national boundaries. And also, we know that internet has several positive attributes, including speed, accuracy, quick access of information, effective communication, convenience, and cost and time-saving characteristics, which makes this medium and the sphere so effective and pervasive. But at the same time, there are many peculiarities of this medium. In particular, difficulties in determining the jurisdiction and the feature called anonymity, which often puzzles the online community. The evolution of digital sphere has changed the parameters, and the owners of intellectual property must also use these parameters and come up with strategies to safeguard their original creations. In the digital space, there's a growing trend for online commercial activities, which adds great economic value to businesses. Yet, concurrently, a lot of risks are being posed to such businesses. Unlike the traditional form of trademark infringement, the one that takes place on this digital sphere is highly complex, and it creates a requirement for a stringent IP portfolio and management. Now, through this research paper, we examine the unforeseen trademark challenges that have arisen in the modern digital landscape, and also we discuss applicability of the present law with respect to such infringement. Just before that, I would like to touch upon the dynamic interplay between trademark law and domain names. Now, when coming to cyber squatting, now when a company attempts to register its trademark as a domain name, it promptly discovers that someone else who is not at all affiliated with that particular company's name or the brand name has already previously registered it as their own. This is when domain name issue first became a concern. And this brings us to the issue of cyber squatting. What is cyber squatting? Cyber squatting refers to the act of registering a popular trademark as a domain name with a malified intention of selling such a domain name to the original trademark owners at a high price for a profit. The third parties who are involved in this situation are known as cyber squatters. And the catch here is that the cyber squatters do not own the trademarks, but they go ahead and register them as domain name. For example, if Amazon, before Amazon, which has already acquired its and registered its trademark as Amazon, goes ahead and tries to register it as a domain name, before it goes ahead and registers, a third party has already registered in the name of Amazon, which creates the issue of cyber squatting. Now, the main aim of these cyber squatters is to take advantage of the goodwill and reputation of the companies where the original name has been already trademarked and registered. One of the most significant and first landmark case with respect to this issue is Satyam Info versus SIFnet Solutions, where to just give the brief facts of the case. Here, the plaintiff, which is Satyam's Info, had registered several domain names like sifirealestate.com, sifinet.com, and the word Sifi was claimed to have been formed by using several elements of a corporate name, Satyam Info. The cyber squatter, that is the defendant, carried out its business under domain names www.sifinet.net from June 2001. The Supreme Court held that the domain name is a business identifier, that is, it identifies the origin of the company. They're unable to identify what is the source of that particular content. So in simple terms, it refers to when you click on a particular link, it redirects a particular user to the web content rather than the home page of that website. It essentially invalidates the navigation options offered on a website main page and its intended navigation options. So one of the major impact of deep linking is loss of profits, where the deep links cause fewer clicks on a website main page, which decreases the traffic and reduces the amount of money that can be made from a homepage advertisement. Moving on to the next type of challenge, that is inline linking. In inline linking, the hyperlink text of the web page itself is changed and modified. Here, it guides the user to another page containing related information. And moving on to the next type of challenge, product disparagement. The main function of a trademark is we all know that the main function is to act like a source identifier, and it helps in distinguishing goods and services from other brands and companies. In India, comparative advertisement is permitted, but the advertiser cannot go to the extent of disparaging the product or services offered by the other companies. Disparaging simply here implies that the advertiser should not make a false statement or a degrading statement about other company and harms the reputation of another person or product or the services offered by them. This shall not only constitute disparagement, but also it amounts to trademark infringement. And Section 30 of the Trademark Act 1999 clearly provides for comparative advertising, with the exception that nothing shall harm the reputation of another person's trademark, nor it should harm its distinctive character by taking any undue advantage. The comparison in an advertisement must be seen as a whole and not in its parts, so that the real intent or the message that it tries to convey can be comprehended in a better manner. Now, my co-author, Ms. Kirtana, will explain the other end of the paper.
So good afternoon, everybody. So I'll be taking over from meta tagging. So meta tagging is nothing but there are snippets of the text that describes a web page content. So how it does is that the source code will always contain certain keywords of a particular brand or particular trademark for that matter. So for example, say there are Google ads that takes place in the social media websites, right? So these meta tags will be included in their source code, and they describe the web content of that particular website. So sorry, the third party's trademark as a keyword constitutes a trademark infringement, or whether it is considered as a fair use. So these meta tags are just that it is embedded in the source code of a website so that it can be identified by the search engine optimization software, and that when the users select these particular keywords, they'll be able to get that chosen meta tag product. So this one particular case where it talks about meta tagging is a very recent case of DRS Logistics versus Google India. So this was a case where the plaintiff had taken an action against Google India for using their trademark as a source code of another company. So in this case, the court held that the complaints made by the plaintiff with respect to the usage of their trademark as keywords was amounting to trademark infringement, even though it was not visible to the naked eyes of the customers or the users of the users on the internet. So now we'll be moving on to the social media challenges. So what are the trademark challenges that are present in the social media platform, right? So in this age of digitalization, social media has actually evolved in a crucial tool for brand growth through advertisements, endorsements, and promotions on such platform. And here, promotion doesn't mean a normal sort of promotion that happens in a physical world, but here it tends to be more of a paid promotion. So the businesses use such media platforms like Twitter, Facebook, Instagram, and other social media, share chat also for that matter, and others to expand their reach to potential customers globally, so that they can reach to a larger and a very broad range of audience for their marketing strategies. So one such method they use is that use of hashtags to promote their products on social media websites. So hashtags is that it's a method.
Sorry for the interruption. Can you just wind up with a couple of minutes, ma'am?
I'll be winding up in next 1 minute.
Yes, ma'am. Thank you.
So we come to the question that whether a hashtag can be trademarked or no. So this hashtag increases the search outcomes. So basically, whoever uses these hashtags, they'll be so whoever uses these hashtags, they'll be able to reach to the particular source or origin of such a product, right? So so where this brings us to a question whether the use of such hashtag for promotion or advertisement can be trademarked or no. So if we see into the Indian scenario, that is according to section 2 clause ZB of the Indian Trademarks Act, it provides two criteria for registration of a trademark. One is that the mark should have a capability of graphically represented, and the second thing is that it should be capable of distinguishing the goods and services of the other person. So here in this case, hashtags are graphically represented, and second thing is that there are high chances that it is able to distinguish the goods of one company to another brand, right? So there are instances where US nations Patent and Trademark Office have registered trademarks of Coca-Cola brands with a hashtag saying hashtag smile with Coke and a hashtag Coca-Cola pics and all that. So their ground was that it is graphically represented and it has a distinctive character to be able to distinguish. And there was this very famous case of Frankfurt Aviation Services versus Tata Sia Airlines Limited. So this is where the case where the plaintiff had a registered trademark for Fly High, and the Tata Sia Airlines, also known as Vistara Airlines, they have been using the tagline hashtag Fly Higher for their promotion on our social media. So in this scenario, Frankfurt was claiming trademark infringement against Tata Sia Airlines, but the court in this case held that this will not amount to infringement because of the fact that Tata Sia is using the hashtag Fly Higher along with their registered trademark Vistara. So there's no likelihood of confusion that will be existing among the customers. And Frankfurt Aviation Services is a company that offers is a company that is totally dedicated to training cabin crews for aviation. services, right? And Tata Sierra Airlines is an airlines company, so this is a completely different category of services, and they have been registered under separate classes according to these classification, and hence this will not amount to likelihood of confusion among the customers. And this was held by the Delhi High Court. So we move on to the last part of our presentation, that is whether social media influencers will be amounting to intermediary liability, because social media influencers in the recent times have been involving themselves in advertisements, endorsements, and paid promotions on social media. So what is their liability? Will they also be included as intermediary liability just like a social media platform, or will they also be liable for their own actions or for their own misrepresentations of the trademarks of any of that sort? So one of such cases is the Marico Limited Abhijit Bansali, which highlighted the duties and the responsibilities of a social media influencers, where the use of the trademark by the influencer should not occur in a manner that would misrepresent the brand, or in a way that would mislead the customers about the origin or the origin of the goods and services of the brand. And also there should be no possibility for trademark to be diluted. And there's been a very recent amendment that was brought to the Information Technology Act, which is known as the Intermediary Guidelines and Digital Media Ethics Code Rules 2021, which expressly provides that social media platform have the safe harbor principle as enumerated in the 2011 principle as well, but provided if they follow due diligence and due actions and appropriate actions has been taken by them. But whether social media influencers are included in the intermediary guidelines, mark, because it's a gray area in law, because it has not been provided for in the rules. So next we'll be moving on to the suggestions. So what are the suggestions in the way forward?
Can you please conclude your topic, as we are having many more presenters?
Yeah, can you give me like 30 seconds? I'll wind it up.
Yeah, ma'am.
Yeah. So first thing is that strengthening the IP portfolio. So IP portfolio is nothing but the IP assets that a brand has. So managing that IP assets is a major task for a brand and as for a law firm, right? So we have to, for protecting that, so the defense mechanism of protecting a brand's trademark is which will determine the IP value of a brand, right? So first thing for that is that the proper cease and desist notice should be followed, and should be sent to people who have been infringing a brand's trademark or copyright for the matter on an infringing site. And after that, necessary steps have to be taken to take down the necessary steps to take down for the internet service providers like Google, Yahoo, and social media websites to remove the infringing content, and it should be removed within 36 hours of publishing it, with 36 hours of receiving the actual knowledge. And one more thing, as we see, is the monitoring program that is online brand protection, where there are companies which offer services for their clients to monitor whether there are any infringement that takes place in the cyberspace. So through these procedures, we can actually reduce the brand infringement and protect the IP portfolio and manage it in a very wider space for the brands. And this is what our research talks about. So thank you so much.
Thank you, ma'am.
Nice presentation. Next participant, please.
Further proceeding with Ali Raza, co-authored with Sarah Junaid from Department of Microbiology, Molecular Genetics, University of Okra, Pakistan, co-authored with Dr. Rangaswamy D, Assistant Professor of KSLU, Hubballi. Dear presenters are going to present on paper Patenting Microorganisms, a comparative study of India and Pakistan. Over to you, madam.
Hello, everyone. Is my voice clear?
Yes, ma'am.
Okay, I am going to share my screen. Is it visible? Is my screen visible?
Yes, ma'am.
Okay. Just give me a screen. Okay. Hello, everyone, and dear participants. Good afternoon. Today, I am going to present on patenting microorganisms, a comparative study of India and Pakistan. So, come towards the patent. Patent is one of the intellectual property rights relating to a legal documentation provides the inventor an exclusive right to the inventor for the limited time period provided by the government to the patentee. Now, what is the purpose to be the patent? It provides the inventors with a way to secure their ideas and inventions. It also allows the inventor to try to misuse or sell the invention without the authorization, and as well as patents can also generate the income, making them valuable assets for the person and the government. You have an idea now that what the patent means. Now come towards the another definition, which is known as the intellectual property rights, also known as IPR, which can be defined as ideas, inventions, and original creation of the human intellect to confer the status of property. Now come towards the term of the microorganism. As you all know this terminology, but I am going to elaborate it little bit for you that microorganisms are the mini creatures which are unable to see with the naked eye. First classical patent was granted to Louis Pasteur in 1873 for the development of the fermenting beer due to its superior and the highest quality via the yeast in the highest amount. There are the three criteria for the patenting the microorganisms. The first one is the novelty. The microorganism should be the novel one and it shouldn't be used anywhere. The second one is the inventive step, and for this, the microorganism must have the non-obvious characteristics. The third criteria is the industrial applicability of that microorganism in the various industries, including biotechnology, pharmaceuticals, agriculture, environmental engineering, biofuels, and as well as the food industry. Now come towards the process and the steps for the process of patenting the microorganisms. There are the 5 steps, and one by one I will explain all these. The first step is the identification and the isolation of the microorganism, and it can be done from the various environments, including the natural environments and as well as the laboratory techniques used in vitro analysis. The second step for patenting the microorganism is the characterization of the microorganism via their genetic makeup, including their physiological properties and as well as their potential applications in the industry. The third step of patenting the microorganism is the patent search, and it includes the comprehensive study of the novel microorganism, which has to be the patent. The fourth step is the filling and examination of the patent application in the specific preserve that microorganisms for the specific time period for the further use. Now come towards the IPR. IPR, also known as the intellectual property rights regarding the use of microorganisms and the microbiological research for commercial purpose, is still in preliminary stage as compared to the other areas of IP. Patent is the strongest form of IPR, and TRIPS, including the agreement on trade-related aspect of intellectual property right, is the most important international agreement of IPR. Now, come towards the next step, including the patenting of microorganisms in the India. So according to the Patent Act of India 1970, Section 21J34, the invention is defined as a new and useful manner of the manufacturer as a substance produced by the manufacturer. So criteria for the patenting is, in 1971, Dr. Ananda Mohan Chakravarti was granted patent on genetically modified bacteria which have the ability to digest the oil spills in the water. The patent was claimed on the bacteria itself, method of the modification, and the introduction of the vector. India Patent Act, according to the 1970, didn't patent the animals or the plants. However, microorganisms and non-biological and microbiological process of production of plants and animals and members will provide the protection to the plant varieties either by the patency or by the effective sui generis system. Now, come towards the IPR in 1980, and according to that, the patent was just assigned to the processes related to the microorganism rather than the microorganism itself. So, Chakravarti is known as the father of patent microbiology because he won the US Supreme Court case according to get patent regarding the oil-eating bugs known as the Pseudomonas. Here is a glimpse of Ananda Mohan Chakrabarti gaining the patent of that microorganism. Now come towards the history. In 1856, first provision in the nature of patent rights was developed. However, in 1872, the Patents and Design Protection Act was developed. In 1911, the India Patents and the Design Act was developed. However, in 1970, Patent Act was developed, and these patent acts were modified in 1999, 2002, and 2005. Further amendments was done in the following years. Now come towards the Indian scenario. Patent Act in 1970, they added the microorganism under the purview of patentability through the Patents Amendment in 2002. And according to the Section 3J of the Patent Act, plant, animal, seeds, and biological processes apart from microorganisms are not patentable. Therefore, Section 3J of the Indian Patent Act allows patentability of the microorganism. Since 2001, the two major patent, you can say the patent collaborative organizations were developed known as the MTCC and MCC, known as the Microbial Type Culture Collection and Microbial Culture Collection. However, in 2002, the Government of India permitted the patenting of the microorganism under the Patent Bill. Still, there exists a big debate regarding the patenting of microorganisms in India. There is critics for the patenting of the microorganisms. So according to that, Indian culture as per Smriti states that knowledge and its benefits should never be taken into the custody. So the strongest argument in favor of this is that microorganisms are the natural living organisms and they are just isolated from the environment. So we don't invade them. That's why whatever we are obtaining from them, we can't patent it. So this is the main critics about the patency of the microorganism. Now, come towards the patents rules in the Pakistan. And according to that Act of 1911, according to the modification in that Act in 2000, several official documents, including Intellectual Property Organization of Pakistan, done to comply with the requirement of the TRIPS agreement. And according to the patent ordinance, all inventions are patentable if they meet the usual condition of novelty and the industrial applications. There are some key details about patenting the microorganism in Pakistan, including patentability criteria, patent application process, examination and grant, duration and protection, and as well as rights and enforcement. Pakistan Patent Ordinance specifically denies the protection to products existing in nature or isolated from. However, cloned and modified genes are patentable. Methods of genetic modification of seeds are also patentable. Genetic engineering is also patentable, as well as biological synthesis of the new microorganism in the environment is also patentable. Now come towards the process how to apply for patent in Pakistan. So in accordance with Section 11 of Patent Ordinance 2000, anyone who is true and first inventor of the invention. Second one, the assignee of a person claiming to be true and first inventor as the legal representative, deceased person who before his death was entitled to make such an application. There are different criteria for the patent search in Pakistan, including the patent number, application number, name of patentee, title of invention, subject matter, as well as the classification of the patent. There are the different types of patent applications in Pakistan, including ordinary application, provisional and complete application, as well as conventional application, patent of addition, and divisional application. There are the two methods of filing a patent application in Pakistan, including the submission of the physical copy. However, you can also submit the application electronically. Now, come towards the issues involved in the patenting of microbiological inventions, and it includes the novelty of the patent, relationship between research and development and industry, employing people with knowledge and IPR, lack of knowledge, relevance of convention, reproducibility, and scope of patent. So, in conclusion, I will say that patenting microorganisms can be a complex and time consuming process, requiring expertise in both microbiology and intellectual property law. Additionally, patent laws and regulations vary from country to country. The patent laws followed by India and Pakistan and the prospects to boost intellectual property rights framework and legislation in the global perspective. So thank you and welcome for questions.
Ma'am, the paper presentation has come to an end. I request chairperson and co-chairperson. Ma'am, Dr. Anuja Mishra, ma'am.
Yeah, sorry, I was muted actually.
Yeah, ma'am, the presentation has come to an end.
Yeah.
So do you have any inputs on this issue?
Sure.
Yes.
Good afternoon, Dr. Rangasamy, Professor Rangasamy, sir. And I am really very thankful for their invitation and really felt privileged to chair the session with my chair, Dr. Lipika Dattaji. And there have been very nice presentations. Most of the presenters were already academicians. So I really liked most of the presentations, basically specifically presentation done by Aditi and presentation done by Ms. Sara Junaid and a presentation by Tomojit Ghosh, relationship between IPR and human rights. And they have touched almost all the relevant and all the sensitive issues regarding the IPR, human rights, and artificial intelligence. As nowadays AI has become part of our day-to-day life, and it is actually, I must say, it is encroaching everywhere. Either it is our life, either it is our road traffic, either it is our as we are concentrated on our conference on the IPR. So in the IPR, there are also innumerable issues regarding the infringement of IPRs because the area is getting vast day by day. So the more uses, the more misuses, and the more infringements. And as far as we talk about the laws, there are a lot of issues in India where we do not have a strong existence as far as our legal existence is concerned. As one presenter was Mr. Gangamai, he was talking about the IPR issues in space. but we do not have any, it's really sorry to say, there is no specifically a law which is working or which is being implemented in case of IPR infringement in the outer world space or in case of space. So overall, it has been a very nice experience to be a part of this international conference, and all the presenters have made a very good PowerPoint presentation, and I'm really very much thankful to all of you, and keep it up. Thank you, Professor Rangasamy sir, and that's all from my side.
Thank you, madam. Thank you very much.
Yeah,
much
or you
for
are
your
most welcome, sir.
for
Most welcome,
accepting
much
our
obliged.
invitation, being part of such a lengthy session. So we are extremely sorry for that. So somewhere we
No,
failed
no,
to
sir. Please don't
track the
feel
session.
sorry.
Sorry
It,
as for that.
I'm also an academician. It used to happen whenever we organize the programs, because all the times you can't interrupt the participants. It doesn't feel good. Most of them are also academicians, so interrupting them again and again. And even if we are giving them 10 minutes, this is not at all sufficient. A person who is writing a paper of 15 to 20 pages, or 5,000 to 4,000 or 6,000 words, so 10 per minutes even not sufficient for that. So that is okay, it happens sometimes, and I really felt good. Yeah, thank you very much.
Thank you, madam. Thank you so much for your kind words, madam. So once again, thank you. So with this, we will be concluding this session.
Sure.
We will be starting our valedictory program at 3:30. I request all the participants to join that valedictory program. Thank you, Anuja madam, once again.
Thank you very much, sir. I hope further academic collaborations in future, say, as
Yeah,
usual.
it will be, madam. It will be. There would be standing invitation to you, so it will be part of our future academic events, madam.
Sure, sure. Thank you very much, sir.
I now extend my deepest gratitude to all the presenters for their remarkable contributions. Also, a special thanks to our audience for their active participation and engagement throughout this session. Thank you all and have a good day. Thank you.
Recording in progress.
Okay. So then I think I have to request Ajay sir. I'll just request him, like we will commence at 3:30.
So what is the time, madam, according to schedule?
Sir, it's like 3 o'clock, sir.
Oh, yeah, okay, okay. Then we could start at 3 o'clock only, if that is the case. Anyway, we have
Actually,
20 minutes.
I think I had a word and I've shared also that flyer. So accordingly, then we have scheduled 3 o'clock, because we thought from morning today we do not have any any particular session, expert session. So we thought through presentation, I think parallelly we will able to complete it on time.
Yeah, we did that, madam. But despite some because of some paper
I can
presentations,
understand, sir. I can understand.
Yeah.
Are really not in our control, sir. Yes, sir.
Okay, okay. So we will be starting exactly at 3 o'clock, madam. So we'll be starting.
Yes, sir. Yes,
So
perfect.
I request those who are in this general platform. So we will be starting our valedictory program exactly at 2 o'clock. So I request you all to be with us or join at 2 o'clock.
Yes, sir. Yes.